Then what happens, Dave?
Well, the question that kind of came up is, is a handshake agreement binding?
Oh, that's a good one. That one I don't have to give the lawyer answer. The lawyer answer is it depends. But in that case, a handshake agreement is binding. Verbal agreements legally are completely binding, same as a written agreement. But the obvious issue is proving them's not as easy as proving a written agreement.
Yeah, so from that point, if you're turning around and saying that a handshake agreement is binding, but does that mean that there needs to be potentially other people that have seen that? Because it's your word versus someone else's.
So if you had witnesses to it, that'd help. And actually shaking hands is an indication that people have agreed, right? It's a sort of a symbol of agreement, if you like. Without getting into the kind of the nitty gritty of the law, in order to have a binding agreement, you need an offer and an acceptance. You need consideration, so you need one party promising something to the other party and vice versa. Otherwise, it's a gift, right? If it's just a one-way thing, it's a gift, not an agreement, and a gift is not necessarily binding. You need the parties to be intending to be bound. And so a handshake is a symbol of intending to be bound, The other thing you need is it needs to be specific. So you need enough specificity, You can't just have a vague discussion and then that becomes a binding agreement because it's too vague to be legally enforceable. So if you've got all of those things, witness or no witness, then you've got an agreement. But of course, it's very difficult to prove. But what I find in the modern world is that if you do have a verbal agreement, it's often, there's a whole bunch of surrounding circumstances and actions which you can prove, like emails, follow-up conversations in front of other people, stuff you've done, conduct, you know what I mean?
Yep.
And all of that, if you look at all of that, obviously that can often evidence or show that there was a verbal agreement. If you've agreed to something and then handed over some money and someone else has handed over some goods, there must be some agreement,
But then is that, so from that point of view, if there was the intent, that was the intent of someone's discussion, and does it then potentially also move from being a legally binding agreement to also then perhaps an ethical and a moral obligation in that someone has there's been a conversation between two people and there has been a handshake and we had this and the discussion went on for several weeks and therefore I took it in good faith that we were progressing towards this and we never actually documented the agreement. However, the intent was that we were to build something or do something together and therefore it was this situation. I mean, is that also part of it? I suppose when you turn around and say the terminology becomes, is a handshake agreement binding? Well, sometimes there may not be a handshake, but it's the intent of what the discussion was and whether there's been, whether it be a single discussion or a multiple discussions, that therefore the intent was behind that agreement, irrespective of, whether there was an official handshake that said, oh, that's an agreement.
Yeah, you don't need an actual handshake. You can just have, a single discussion could be an agreement if it has all of those things, has the offer, acceptance, consideration, it's specific, and the parties are sort of intending to be bound by it in all the circumstances. That makes a binding agreement. But you can see why people like me favour legal written agreements, because if they're in writing, it's very clear that they're specific. It's very clear that there was an intention to be bound when you signed it. Whereas if you just have one discussion, it becomes a real a mess in terms of trying to prove what was agreed or what wasn't. And people, of course, forget over time. People's memory changes, or people can have, as we've all had, we have a discussion and two people can walk away from the same discussion with different views about what was agreed or not agreed, right?
The discussion that we're having here today is around, is a handshake agreement binding? So as part of that, if there has been that discussion between two parties or multiple parties, best case is get a legal document drafted, but a lot of people don't like to do that. Sure. But is the next best alternative to at least follow up in some form of written document that says, as follow up to our discussions, this is what I understood the circumstances to be, and at least document it on that basis? Is that a good suggestion that business owners potentially should take going forward?
Yeah, I think, look, in terms of day-to-day guidance, you don't want to be going off to a lawyer and signing up a new agreement every time you agree something with someone. I think you just have a discussion on the phone and then send an email which says the following terms were agreed, 1, 2, 3, 4. And if that someone else sends back something saying, yes, that's right, then that's an agreement, no question about it. And even if they don't do anything, that's reasonably, it's a reasonable assumption that they've agreed because they haven't taken issue with what was said. So that's hugely helpful. So I'd say, yeah, and that's just good practice in business, right? You just send an email afterwards so that everyone's clear on what was discussed, even if you don't intend on suing anyone, right?
So is voice recording the same? Like instead of an email, someone may prefer they send a voicemail to someone that records, their intent of the follow-up of the discussion. Would that be also classified, an appropriate way of recording what was occurred?
Yeah, it's all, like legally, it's all just a matter of evidence. If you either have an agreement or you don't, in fact, and then it just becomes a question of evidence. If you have a voice note that records it, that's good. If you have it in writing, signed, that's even better. They're all just evidence issues. So as clear as you can be with your evidence, as good as your documents can be, the better position you're in. And I think your business process, for a business owner, you want a good process where when you make agreements with people, if they're formal, serious agreements, they're documented. And if they're kind of, day-to-day type things, then they're just in emails or in some sort of document that you can read and that you can go back on, Even just forgetting about the legal stuff, just practically, so that you can go back and say, oh, hang on, what did we discuss 3 months ago and what was agreed?
Does that also potentially apply to... it may be the owner of a business, but is it also potentially some employees that may have had, they're senior people or they've got the capacity to make decisions on behalf of the company? Is that also a situation for certain employees that they may have discussions with third parties that then puts the business to an extent where they have an obligation that someone is providing a service or offering a product based upon that conversation? Is that also another reason for people to document that? Because sometimes the owner may not know, but it's a third party that, as a senior person, has said, oh no, I committed to that. And they're like, wow, I didn't know that. Yeah,
so that's a question of authority. Does that person have authority to enter that agreement? And the law says if you've got, if it appears in all the circumstances that you're acting on behalf of a business, so if you're called a director or you're called a senior manager or something, you got the kind of title and you're dealing with someone on behalf of a business, they're entitled to assume that you do have authority. So if you have a verbal agreement with someone who appears to be representing a business, that business might be bound by that, even if the boss doesn't know.
But then are we getting to the point, part of it do we get to the point that we're arse covering the whole time, that all of a sudden everyone's got to cover this and you've got to document this, which then makes it so much bloody harder for everyone? I know it keeps a lawyer in a bloody job.
Because all of a sudden... how very dare you, my friend, how very dare you. All I do is arse covering, that's my whole job. Which is, it's more risk management generally, you know what I mean? Like that if you do a deal, send an email saying, look, this is what was agreed. And then if they say, no, it wasn't, at least you can sort that out there and then. That's just being practical, right?
Have you got some examples where you go, oh yes, so-and-so came in without giving names, clearly, that it's like, wow, hindsight is a beautiful thing.
Yeah.
And have you got any circumstances that you've seen in the past that you think, this is my learning through that I would have, if we'd done this and this and this, it would have enabled, a better outcome? So
the obvious one, and it has happened to me a couple of times, is I had an agreement with so-and-so, but now they're dead. Right?
Wow.
So, you don't want to be too morbid about it, but you say, well, it's going to be pretty hard to, for that person to explain what the nature of the agreement was if they're not around anymore. Now, obviously, you can look at the circumstances and so on, but when people pass away, that's the kind of most obvious one, that if you have an agreement in writing, then their estate's bound by that, but if they've died, then very difficult to prove what the agreement was or wasn't. So that's kind of the obvious one. Another one is they go bankrupt. If that person goes bankrupt, then the trustee of the estate becomes responsible for their estate, for their assets and so on. And so if there's a written agreement, again, that's likely to be honoured by the trustee. It might not be, it's a bit complicated, but certainly if they go bankrupt, you're much better off if you have a written agreement. But then just the time passes, and the agreement evolves, if you like. So does that then happen where there may be two business partners in
in agreement on stuff, but the spouse then comes in and sort of says, well, this is what, Johnny told me the situation was.
Yeah.
You're saying it's not. And that was my understanding. That's what he told me. Have you seen circumstances where that occurs?
We've seen where the spouse, so two, say, men are in business together and there's two wives, and one of the men dies, and then really the surviving man is now in business effectively with the estate, so with the wife. The wife might be the trustee of the estate or the executor. Yep. And so now... and the wife might have a different view about what was agreed or what should be agreed or what should be done, right? And obviously they've just been through a massive life challenge, and so they might be looking to cash in or cash out or whatever, and that's a big challenge when you don't have anything, particularly around, say, partnership agreements. You don't have any partnership agreement in writing. It's always just been worked out on a handshake, which might be fine while you're alive, but not fine after.
So do you find it's more when businesses are starting that they have some of these things where there is a discussion, two individuals start a business together and, they kind of talk about all this stuff. But as the business starts to grow and get bigger, we've always sort of split everything 50-50. Oh, we've always sort of done it this way. Is there ever a point that you see for businesses that then turn and go, you know what, actually we should document this?
So normally they either do it at the start, the very beginning, you go, okay, that's a time for a partnership agreement, or they do it once they're sort of financial. So once the business is successful, and I can sort of understand the logic in that. You don't want to go off and spend money on a lawyer when you're just starting out, but once you've got a few clients and you've got your cash flow going and all that, then that's the time. Or when something changes, so they decide to bring a third party in, or often you get to a point where you want to get investment in, and the investors won't invest unless you've got a shareholder agreement or whatever. And they're not going to be, if you're looking at investments, they're not going to be looking at a handshake agreement and thinking that's okay. You're not going to invest in a company that's handshake agreement. So that's the other part of it. There's a sort of a certain level of kind of professionality that investors and that the market expects once you get to a certain size, and your handshake agreement isn't going to cut it if you're trying to do a distribution agreement in Italy, or you're trying to do you're trying to grow beyond kind of mum and dad and the lad, as they say.
But you do still see that. I mean, you still see these. These are some very successful businesses that may have agreements with distribution agreements with international suppliers. And a lot of people go, but we've always done it that way. Why do I need to kind of change?
Yeah, well, I did a big dispute recently over film rights, and that was a handshake agreement. In fact, there was a written agreement, but it was very vague, and there was a handshake agreement. And that was one where the fellow who the handshake agreement was done with passed away, and a new CEO was took over. And then that person had a different view, and the whole handshake thing fell away. And this happened. We've had our own clients, the person we've had the relationship with has been replaced, resigned, whatever, moved on. And then suddenly you've got a relationship with a different person. You've got to go back to your documents and go, hang on, are they all in order? Because I might have done the deal 10 years ago, but now I'm dealing with a different person who might have a different set of priorities and might not get on with the same way. People come and go. Forgetting about death, people come and go in business, right?
If we talk about the topic again for today is a handshake agreement binding?
Yeah.
And the answer is it depends, and whether that can be backed up or supported through other written agreements or forms of communication, even though it may not be a legal agreement. But also that then comes back to how do you support the valuation that you may put on that particular asset? So a handshake agreement between two parties may be substantially less valuable to a business owner than if they'd had it documented.
Yeah, that's right. Or you might have you might have been, say, distributing product for someone, or had a customer that's been with you for 10 years. But because there's no written agreement, that customer can leave at any time by giving 30 days notice or no notice at all, right? Whereas if they might be happy to sign up to a 10-year distribution agreement, 10-year whatever it is, a retainer agreement, whatever. And then suddenly your business is worth a lot more because you've got these long-term supply contracts. But you can really add value to your business by having a long-term agreement in place rather than, the handshake. And as I say, you can still have a handshake in addition. There's nothing stopping you doing any deal you want with anyone, anytime. But having a long-term written agreement, if you're trying to build a business over time and build the value of the business, then surely having long-term supply contracts on one side and on the other is going to add value to the business, right?
Yeah, which then goes back to the building blocks that we talk about. If you're building a business, you want a solid foundation. And a solid foundation is driven on agreements that are in place that other people can look at, but it means that you've got the stability rather than, but it's in Alex's head, the knowledge of this. It's like, no, this is written in an agreement and we've both signed off on both parties, which means that we can continue to build with, I suppose, certainty and an understanding of what that agreement is.
Yeah, well, it also means that then if the business owner wants to, have a holiday or maybe they want to put the business under management over time or eventually sell the business, that what they're selling is valuable and, as you say, is not just in their head.
So why is it that people are resistant to drafting an agreement? Like, is it sort of, look, there's a trust element? Is it, look, we've been mates for years? Like, well, yeah, I mean, maybe that. Yeah, well, they always think these, the leeches of the legal fraternity, which is very unkind, really, isn't it?
I wouldn't have put it that way. That's taking it a bit further than I was going to. Thanks. I think there's a couple of things going on. I think one is expertise. Sometimes you're dealing like engineer to engineer, and they both speak the same language, and they sort of see if they get lawyers involved, lawyers will slow things down, which can happen. Lawyers will get in the way. They just want to do the deal. So I think there's a lot of that kind of, I don't.
Or is that referred to as confusion with jargon?
Well, it's a different kind of jargon, So we write really long sentences with no punctuation. That's where I
correct. Most people could probably write them in about 3 words, but a lawyer likes to, make it out in about 3 sentences.
Yeah, actually, I had a client, I did an agreement for her, and it was about 7 pages long, and she said, "Oh, that's great, but can you just take out all the bullshit?" Sorry, what?
It's a one-page agreement.
If I take out all the bullshit, there'll be nothing left. I said, well, I can, but if this was an agreement, an international agreement, so I said, okay, well, there's a big clause in here that says what happened, which jurisdiction are we in? Does that worry you? If I take that out, are you happy for them to sue you in Morocco, or do you want them to sue you in Australia? And she said, oh, no, I want them in Morocco, right? I want it in Australia, sorry. Okay, no worries. And, the bit that says, there's an indemnity or a warranty, are you happy to take that risk, or do you want them to? Oh, no. So when you actually go through it, you go, well, hang on, there's a whole bunch of what-ifs in this agreement that actually help me, hopefully, It's not just all bullshit.
But part of the bullshit meter is the noise that it makes when you drop it on the table.
Yes.
You don't want something soft hitting there. You want a lot of pages to kind of really, give the desk a bit of a belt, because it's just. And then it winds them up for years. They're going to work their way through it and come back.
Oh, mate, no one ever reads it anyway. You just hand it over and they sign it.
But is that part of the issue, I suppose, for some people, that they turn around and they say, well, that's exactly why we've got this handshake agreement. I trust Alex. There's no issues with it, and it's good when it's good.
Yes.
But then they turn around and go, because these bloody lawyers, they've drafted this thing, and I've got to work my way through, and it's going to cost me a fortune to do it. Is it a little bit of the, let's not add expense to something that's not necessary because we won't have a dispute.
I follow all that.
An issue for some people.
Yeah, but it's really just a question of, well, when is it appropriate to get, a lawyer? When is it appropriate to say not document it at all? When it is appropriate just send an email? When's it appropriate to write a document yourself? And when's it appropriate to get a full-on lawyer and have them get a lawyer and so on? And it's really about the value of the transaction. And it might be that the transaction's small at the start, but 10 years later, suddenly you're building a multi-million-dollar business and it's off the back of a handshake. And I mean, that's just not sensible planning.
Well, I think that's the point, though, isn't it? If you, again, the topic of today is a handshake agreement binding? Yes, it is.
Yep.
But then it comes back to how can I monetize what that agreement that may have been initially a handshake agreement progress to the next stage, and how do I monetize it in a way that I can either, one, bring in investors or sell what has been developed to a third party, and therefore it is that building component that sits in there. And I think that's always a real challenge of the negative views of going to a lawyer to get a documentation done versus, yes, but how do you build and how do you monetize this amazing asset that has been built?
Yes. Yeah, the thing that really turned the light on for me about this was someone said to me, a business isn't a bunch of people. A business is actually a system. And obviously there's people involved, and I'm not trying to underplay the value of people, absolutely. But a business is a system and the more the more systematized it is, the more valuable it is. And contracts are one of the kind of systems that they're not relying on a particular individual, because people come and go, and people forget, and people change their mind, and all of that sort of stuff. And if you have a really strong system, including long-term contracts, so that you can make sure whatever you're buying from people you can always get, and whatever you're supplying to people you can always supply, and you're growing your customer book with long-term contracts, then you're growing real value. And so, just contracts are just part of that. You can certainly do a handshake agreement, nothing stopping you in that, you'll be bound by that. So that's great, but it's going to be difficult to prove. It doesn't deal with the what-ifs, and in the long term, if it's about a lot of value, then in the long term, I think you're doing yourself a disservice, because you're underselling the value of the business, by not having the written contracts. And you've got to come to me to sort it out.
Well, which then comes back to the discussion around, do I spend a little bit up front to get something in place, or it's like, well, you don't need to do anything if you don't want, but if there is a dispute, no problem. Come and see the lawyer, and instead of being 10 grand, it might cost you 100 grand.
Yeah, but it's just part of the really sensible business planning.
But do you think it's also like an evolution that's occurred, that people are becoming a little bit more litigious in the way that they want to deal with stuff? So therefore it's a protection mechanism that the two parties that are interested in it may be okay, but it's when, like we gave the example of a death or some form of dispute or disability within one of the partners, then there's a third party that comes into the discussion that says, oh, well, that's not documented. I don't agree with the way it's been going. Is it because people are becoming a little bit more litigious? That
I don't know if people are becoming more litigious generally. They might be, but I certainly think it's really a misunderstanding. That's what I see. It's not a good guy and a bad guy in the dispute. There's really just things have been misunderstood, and it's got worse and worse. The tension's built over time, and eventually, when you have a fight with someone, but after a bit, whatever they say upsets you. You know what I mean? Especially if you had a close relationship previously, and they've done something to piss you off, then suddenly they can just sort of can't say anything right, because anything they do you'll find fault with, and that's what sort of happens.
Yes.
In the trench throwing hand grenades at each other instead of having a reasonable discussion. And again, the topic today is handshake agreements, and are they binding? But if you had a written agreement, then you can at least go back to that and say, well, before we were throwing hand grenades at each other, we wrote this down and this is what we agreed, and that's the rule book. Now, it might not solve all problems, but it's certainly a good start.
So what about the courts? Are they if the dispute ends up getting to the courts, what's their view on those sorts of agreements? Do they kind of turn around and push back on it and go, well, that's not really, because we've got no basis of a legal decision, therefore it goes back to mediation or something? Oh,
no. So the courts will enforce a handshake agreement or a verbal agreement the same as they will a written one. But it tends to be a lot more expensive to run a case like that. So the first case I actually ever ran to a full trial, and it actually went to appeal, was a verbal agreement. There was nothing in writing at all. There was just a verbal agreement to buy an interest in a business. And we were alleging the verbal agreement, and we won, and then we won on appeal again. So that was good. But, what might have cost... cost $50,000.
Quality legal advice never goes astray, Alex, does it? Even when you're arguing with
the only case I've ever won.
Like, there's nothing like a little bit of self-promotion there on this podcast, I'll tell you.
Well, I suppose the lesson in all of that is I'm great, but the number two lesson... The number two lesson is that you can, we proved a verbal agreement, and we're able to prove it by, the day after the agreement happened, our client sent an email saying, I'm going to do this stuff. He didn't talk about the agreement, he said, I'm going to do this stuff. And that was stuff that he says was agreed, and the other side said it wasn't. We said, well, why would he send this agreement if it wasn't agreed? It just didn't add up. And there were some other, letters and things that went back and forth that were consistent with the agreement. So that's how you do it, right? But you can imagine that means you've got to produce a lot more evidence, a lot more time, a lot more uncertainty, right? So it means if you're going to settle the case, you settle for less probably than you would if there was a written agreement because you're not sure about your prospects. And it actually is a reason for an appeal too because of the way the evidence was. So the appeal adds more cost. So you can prove these things, but they're much more expensive. The court will enforce them, but it's much more difficult to prove. And often you're not really sure whether you're going to win or not until everyone sits in their witness box and gives their evidence. And you think, well, maybe I should have just spent that couple of grand and got an agreement sorted. You know, it certainly, you know.
Yeah, maybe I should really get that agreement with all the bullshit written in it.
Yeah, that 7-page agreement, all that rubbish Alex gave me.
Yeah. Take all the bullshit out. Yeah, well, maybe I need to make it 14 then and not 7.
Well, yeah, it's funny because that happened probably 7 years ago, and I still remember it because I've got a glass jaw, I've got a broken heart. I was very upset about it. I still remember it.
You're not a lawyer at all.
It was very hurtful. So the handshake agreement certainly is something you can enforce. It's just much more difficult than a written agreement.
Yeah.
So, you know.
So if we kind of just put a wrap around this with the topic being is handshake agreement binding, what would be your advice as a lawyer to anyone who is sort of saying, well actually I only have a handshake agreement with my colleagues, partners. How would you wrap it together to say, well, what would you suggest?
Sure.
Some of their next steps moving forward.
So I guess I'd just say for minor things, do something yourself in writing. Maybe medium level things, write something out and sign it. And then major things, I'd go and get some advice. And it's really a matter of spending a little bit of money now or putting yourself at risk over the long term of either having a dispute or of underselling the value of your own company.
Yep. Yeah, so, okay, and then the other side for me, from a financial advice perspective, to me, I would look at that and say, well, you've actually built an amazing asset over the years, so therefore, how do you monetize that? So by at least having clarity around how an asset is to be structured or owned and developed and how that percentages may be set, the clarity of that gives you the capacity to either sell, part sell, full sale through of a business, or pass on to a third party, being either family members or someone else. That from a financial advice perspective, that is a really important thing that I think a lot of people do forget. How do I, monetize and liquidate the asset that I've built that so much capital may have been tied up into? How do I go to that liquidity event that I can then use elsewhere? And by having written agreements certainly helps along the way. Yeah, great. Okay. Is there anything else you want to add to sort of finalise? Any sort of more blatant plugs for, thin-skinned lawyers?
I don't think I could get any more blatant than I've already been. I said I win all my cases. I'm very clever. I forget what else I said. I said some nice things about myself. Correct. I think my plugs are done.
Good. All right. Solid, Alex. Once again, a pleasure. Interesting discussion, and I hope people enjoy. And feel free to reach out to either of us and continue the conversation. So we'll see you on the next podcast.
Bye.